Checked. Hi guys, and welcome to my channel, or welcome back to my channel. My name is Debbie, and today we're going to do kind of like an old school paralegal reacts video, because I was looking through the court websites to see what, if anything new was up. I saw that there was an order where Johnny was mostly successful, and I was kind of looking to refer to what exactly he asked for, because it doesn't explain it in the order. And I was actually able to find the transcript of the original hearing. So this is kind of like Christmas a little bit. That was one thing I really enjoyed about the UK trial. We got to see what was actually being said in the court, whether it was paraphrased or when we actually got to see the actual court documents. So I'm kind of excited for this. So I thought, why not review it? And Johnny was mostly successful, so it should be interesting. But before we get started, I'm just going to kind of give an extra disclaimer. Even though I'm a paralegal, I'm not your paralegal. This is not legal advice for Johnny Depp or anyone else for that matter. So I will be reviewing it, and I will be giving like sidebar comments and commentary, making jokes, roasting Amber maybe. And all of those things are just my opinion. It's legal commentary. Come to your own conclusion. But yeah. So now we got that out of the way, let's get started. So this was a virtual hearing on Friday, April 30th. So one of the documents that issued today were due on January 19th, 2021, more than 3 months ago. Johnny Depp seeks information relating to Ms. Heard's $100 million counterclaim for defamation based on 3 statements made by Mr. Waldman, which damages claims requires facts relating to Ms. Heard's career opportunities over the last decade. Communications, other information relating to Ms. Heard's claims of abuse. In that regard, we will note very briefly that police officers Staines and Hayden testified that as to the key issue in this case, on May 21st, 2016, Ms. Heard had no injuries and there was no damage to the apartments or the condos where they were living, which testimony was confirmed by body camera footage taken by the second set of officers that came to the scene on May 21st, 2016. Ms. Heard's response to the motion to compel, and we do appreciate some supplementation that was done, is misplaced for 3 reasons. Number 1, she talks about producing 1 million pages of documents, which is approximately true, but most of this were social media materials that had been compiled by her for experts which are not responsive or particularly helpful. 2, she says that Chief Judge White previously denied the requested issue, which is respectfully false. Requests that were denied by Chief Judge White were far broader. We heeded his instruction, and the instructions the requested issue today are far more targeted. Third and finally, Ms. Bredehoft argues that these requests are moot based on her subsequent production. Pause the language used by Ms. Heard's counsel. It falls far short of the standard under Rule 49. That is, her subsequent responses do not make clear whether the production sought will to be permitted or state whether any additional documents have been withheld on the grounds of objections other than attorney-client privilege. All documents reflecting the impact of the 8 statements, the 8 allegedly defamatory statements in Ms. Heard's counterclaim. All of this goes to the issue of Ms. Heard's alleged damages in the counter. Ms. Heard seeks to arbitrarily limit the production of these responsive documents. And Ms. Bredehoft actually confirmed that she's standing on this objection just an hour ago when we spoke very briefly. And admittedly, I didn't have too much time to speak with her, but I gave this to her as an example of where we still disagree. She says that she's only producing documents after April 8th, 2020. The logic of her objection is that Chief Judge White sustained Mr. Depp's plea and bars to statements A through E of counterclaims. In other words, the earlier allegedly defamatory statements, 1 by Depp, 4 by Mr. Waldman. And she's saying, well, I only have to produce documents after April 8th, 2020, because those are the 3 surviving statements that survived the plea and bar. While we respectfully submit, Your Honor, that that is arbitrary as it's quite possible, and Mr. Depp should be able to argue that any damage to Ms. Heard's career were not done by the last 3 statements, but rather, and more likely, by the prior 5 statements. In particular, Statement A attached to the counterclaim was the only statement allegedly made by Mr. Depp. It was allegedly defamatory, and that was in the GQ article. And I would respectfully submit to Your Honor that far more people read the GQ article, which featured Mr. Depp on the cover and had his actual words, than read the next several statements that were compiled, of which appeared on Mr. Waldman's Twitter account. So clearly, Your Honor, we believe that it is arbitrary, and if Your Honor should order Ms. Heard to produce all documents reflecting the impact of the 8 statements on Ms. Heard's career. Ms. Heard's communication with studios about Mr. Depp's claims against Amber Heard, the UK case, and the 8 defamatory statements that were filed in the counterclaim. Ms. Heard says in her supplement that she stands on her objections but these are core because they go to the damages to Ms. Heard's career. And it bears noting that Chief Judge White ordered Mr. Depp to produce all such correspondence that he had with the studios about Amber Heard and their relationship over the past 10 years. Really going back to 2010 because you can snapshot of what's happened since 2020. Chief Judge White said you have to go back 10 years with respect to the tax returns, with respect to communications with the studios. We have produced all that. Then getting to the last examples in the first category. Communications between Amber Heard and her current girlfriend, Bianca Booty, and others relating to Ms. Heard's allegations of domestic abuse. Clearly, Your Honor, these are relevant, nor were they limited by Chief Judge White. What Chief Judge White rejected was our overboard prior request where we wanted all communications between Amber Heard, Miss Buddy, and others. And these requests, 35 and 36, are more targeted. We're saying all we want are communications between Miss Heard and Miss Booty and others, any others really, about the allegations that Mr. Depp abused her. They go to the core of Mr. Depp's claims, and they go to the core of Miss Heard's counterclaims. Second category, Your Honor, relates to what we believe is the improper limiting extractions and refusal to confirm that all responsive documents have been or will be produced. And Ms. Butterhoff's or Miss Heard's supplemental responses to her credit should identifies some documents responsive, produced by Bates number, which is helpful, but she fails to withdraw the objections other than attorney-client privileges, or to confirm that all responsive documents other than those that are privileged have been or will be produced. Again, just to get you a couple of documents. Document request number 2. All documents and communications regarding Miss Heard's, compensation for commercials, film, or television from 2010 to the present. Here again, Your Honor, Miss Heard purports to limit her production to documents after April 8th of 2020. The first of the 3 statements by Mr. Waldman that survived Mr. Depp's plea in bar. Clearly, Your Honor, we need to go back and assess. We need the documents over a period of time. We need the documents from 2010 to the present. That's, okay, sidebar, that is true because, for example, I work in personal injury. Usually that we ask for income documents 5 years prior to the accident because it kind of paints the picture of how much they make, which proves or disproves the loss that they had. So if someone's making a claim like, oh, I lost X amount of money due to the accident, if you review the income tax documents, you'll see, okay, was there actually a decrease over time? So that's why they actually go back that far. That was guidance from Chief Judge White when he ordered Mr. Depp to produce documents relating to income from commercials, TV, or films from 2010 to present, which include tax returns. So, Your Honor, we respectfully submit that the court should reject the arbitrary limitation on the damages documents from April 8th, 2020 to present and go back from 2020 to the present. Well, if he had to produce it that far, I think it's only fair that she should too. And getting back to the last few bits, Ms. Heard says she's unaware of whether there are any responsive documents. If Ms. Bredhoff can make a representation that reasonable search has been done, agrees to produce responsive documents. If they are found in a future reasonable search, that may be sufficient. Ms. Heard claims and stated under oath in the UK proceedings that she donated all $7 million from the divorce proceeds that she received from Mr. Depp based on a 15-month marriage that produced no children, that she produced, that she donated all $7 million to 2 charities. 1, the Children's Hospital of Los Angeles, and 2, the ACLU. That was false. That testimony was in fact perjury. This is extremely relevant. Chief Judge White ordered back in December, he ordered Ms. Heard to produce her communications with the ACLU and with the CHLA, which she said she produced by January 4th, 2021. Ms. Heard vigorously opposed, moved for a protective order and to squash our subpoena to the Children's Hospital Los Angeles, which was denied by the Honorable Stephen M. Balwick in Los Angeles. Shout out to your family. And her statement is as follows. The court agrees with plaintiff, that's Mr. Depp, that the requested information is relevant for the purposes of pretrial discovery. Petitioner's public statements and press releases about donating the money she receives from the divorce settlement to charities were made in conjunction with petitioner's allegation that the plaintiff abused her and she was the victim of abuse. Okay. And also because it's like kind of both people, I would think, that are saying kind of the reverse of each other. Like both are saying, you defame me, and the other person saying the same thing. So things like this would also speak to finding the truth of what actually happened, what's going on, and who's credible, who's lying. Petitioner does not deny that she made public statements regarding her alleged abuse by plaintiff, and that as a result, her intent to donate the settlement money to charities have focused on vulnerable populations that are less able to defend themselves. Therefore, the court finds it is relevant to the Virginia action, and mainly to the discovery of admissible evidence reasonably assist plaintiff in evaluating the case, preparing for trial, or facilitating settlement. She also imposed sanctions, monetary sanctions, against Ms. Heard's counsel in California for taking that position. Nevertheless, Ms. Heard took the rather extraordinary step of appealing that to the Court of Appeals, that discovery ruling, and the Court of Appeals California rejected that. That is something that Ms. Heard, this is her testimony, the third witness statement submitted on February 26, 2020. The entire amount of my divorce settlement was donated to charity. Mr. Justice Nichols relied on her perjurious statement when he made his findings of fact. I recognize there were other elements of the divorce settlement as well, but her donation of the $7 million to charity is hardly the act one would expect of a gold digger. Well, that may be true, but he was laboring under the false testimony of Ms. Heard that she gave $7 million to charity. In fact, she did not give a dime to charity. So at any rate, the point of that was to show that Chief Judge White found this to be very relevant, ordered production of the correspondence, and now we're asking for other correspondence related to her perjury as to the issue of charitable deductions. Lastly, these numbers go to drafts of the op-ed that appeared in the Washington Post. These are clearly relevant. Normally, drafts of something might be privileged, but in this case, Ms. Heard is alleging that, she really shouldn't be to blame for this because the ACLU, the same ACLU that she stiffed on the charitable contribution, helped her draft it, and so did her first lawyer. Okay, so sidebar, I think it's kind of weird that the ACLU is so determined to protect Amber when clearly it kind of reads like she's trying to throw them under the bus. So, okay, so this is their third lawyer she's had hired and fired. Eric George told her that it was okay. So Ms. Heard concedes that these documents are clearly relevant, but she says that it was only a limited waiver of the privilege, and that 2 years ago, one of Mr. Depp's co-counsel, she says, agreed that there was no waiver of privilege. Well, she cites an email from Mr. Gilmore back on September 4th, 2019. Well, I would submit, Your Honor, that it doesn't matter what Ms. Bredehoft would like it to say. And more importantly, that email by Mr. Gilmore was sent more than 1 year before the answer Ms. Heard filed, in which for the first time since it was her first answer, she had filed a number of motions to dismiss that were denied by the court. She asserted for the first time a quote-unquote defense of counsel as her fourth affirmative defense. And it was also before Ms. Bredehoft recently called Eric George, who was Ms. Heard's first lawyer, who was dismissed after Chief Judge White denied her motion to dismiss and transfer based on venue. So, Your Honor, we have cited a case, to quote, that was by Judge Allen, which says, and I quote, "Finally, the government has requested an order that states that Mr. Dahlman has waived attorney-client privilege and any attorney memorandum providing advice about the operation of Jetflix, because Mr. Dahlman has not indicated that the intention." Judge Alden wrote regarding prose text assertion of privileges, it is well stated that when a party asserts an advice of counsel defense, it waives the attorney-client privilege with respect to all communications to and from counsel concerning the transaction for which counsel's advice is sought. Ooh, what? Oh my God. Wow. Okay, that is so dumb. Okay, so basically it means that a defense was used, which is called advice of counsel defense. Basically meaning like, well, I just did what my lawyer told me to do. So basically throwing your lawyer under the bus. So it sounds like that's what she used, which not a smart move, okay? Not a smart move. So that is directly on point, Your Honor. And what Mr. Heard is trying to do now is she's trying to hide behind Mr. George and his advice and the ACLU and anybody else who may come across the transom and yet not allow full communications with counsel. That just runs directly contrary to what Judge Alden had found, which is true. If she's saying, oh, it's the ACLU's fault, it's my old lawyer's fault, it's this and this and that, you gotta prove that. You can't they're not just gonna take what you say at face value. Where's the receipts? And contrary to my practice in 33 years, you can't just be a little bit pregnant. What? Okay. Once you have divulged attorney-client privilege, that is a general waiver, at least to the subject. So we believe Mr. Depp should have access to all of Ms. Heard's communications with Mr. George and to the ACLU, but that's going to be litigated in New York, although their behavior has been disgraceful in that regard, having done no due diligence. But, Your Honor, it's very clear, and we'll be coming back to Your Honor because I was allowed. Mr. George was instructed not to answer any questions about his communications with Ms. Heard on the issue of whether he did any due diligence. He allegedly gave her advice on whether her op-ed was defamatory, yet he wouldn't tell me whether he did a scintilla of due diligence on whether her claims are true or whether he even knew what it whether even knew that it was Miss Heard, not Mr. Depp, who had a criminal record for abusing her last girlfriend, Tassia Van. Mr. Depp has no criminal record for abusing and has never been accused by a single woman before Mr. Depp. Miss Heard raising a finger. And finally, Your Honor, I would like to distinguish the case that Ms. Bredehoff cited from Judge Ellis. Finally, government has requested an order that states Mr. Dahlman has waived any attorney-client privilege and any attorney memorandum providing advice about the operation of Jetflix, quote, because Mr. Dahlman has not indicated an intention to assert an advice of counsel, a defense to trial yet, and he has not waived attorney-client privilege. Well, here Ms. Heard has made very clear, and she has asserted as her fourth affirmative defense in her answer that she does intend to assert a counsel defense here. So it's unfair, Your Honor, for her to use advice of counsel as a sword and use it as a shield in denying Mr. Depp to get access to the full consultations relating to her advice to Ms. Heard with respect to whether publishing the op-ed in the Washington Post on December 18th of 2018 was a good idea or would in fact be defamatory. Mr. George did admit that he has never looked at the law of Virginia, which is interesting. Judge is saying Ms. Bredehoff brought up about the word impact, and that word impact is overbroad in just a few of the requests for production. Your Honor, I think what we're getting at with impact is what effect or what commercial impact Mr. Depp's, or rather Mr. Waldman's 3 statements, or all the statements actually, since there are 8 in the counterclaim statements, A through G, what commercial impact that had on her career, because she is suing, as you know, Mr. Depp for $100 million, which is actually twice what Mr. Depp is suing Ms. Heard for, which is ironic because I think their career track record is slightly different. Ooh, the legal shade. Okay. But putting that aside, Chief Judge White rightly ordered us emphatically to produce all documents related to your damages claim, Mr. Depp, and that was defined as going back, to 2010, and we have done that. Ms. Heard's claim for damages is twice as much, and all we ask for is the same. We're not trying to play games or wordsmith. We need the correspondence with the studios. We're saying, Dear Amber, given the controversy, given the statements that have been made, we're not going to hire you for Aquaman 6. That's all that we're trying to get, Your Honor. We're not trying to be overly burdensome. But to arbitrarily cut it off at April 8th, 2020, we're not going to find much about her damages claims. So Ms. Bredehoff. So that's Amber's counsel. Let me start off with some general comments, especially since Your Honor is coming for the case for the first time. I will say that I disagree rather vigorously with an extensive amount of what Mr. Chen Chu has represented. And I'm going to try to go through and show Your Honor all of the places where that's incorrect. Let me start with Mr. Depp, who filed his motion to compel in early February. She filed the identical motion to compel 2.5 months later. Quickly, after we asked if we would have the state to be able to seek leave of this court to file or leave to amend the answer in grounds of defense and supplement our plea and bar because Mr. Depp had exhausted his appeals of the case he brought in the UK. On the findings that he was a wife-beater, he had engaged in domestic violence of Amber Heard on at least 12 occasions and had caused her to fear for her life. All are final. And this is a case that Mr. Depp brought in the UK. Now, we believe this motion was brought today, Your Honor, essentially as a placeholder to further delay our efforts with respect to seeking to apply the UK decision to this court. Okay, girl, that ship has sailed. Let it go. Let it go, girl. Okay, with respect to the motion to compel, there are many developments in the interim of the 2.5 months between filing of the identical pleadings. First, Judge White ruled on demurrers and pleas and bar, reducing the available claims and damages to Amber Heard. Second, Amber Heard produced literally thousands of documents responsive to this kind of RFPs. Not only damages, but on the op-ed, the ACLU, and the Children's Hospital. Girl, haven't you really not released anything? I don't know, we're waiting. Amber Heard then produced a hard drive with literally over 1 million documents supporting her damages claims that are also responsive to these requests for production. It is absolutely 100% false that we have said we're not producing any documents before April 9th, 2020. 100% false. And in fact, the vast majority of our documents predate April 9th, 2020. So, for example, Your Honor, the contracts. Ms. Heard has produced everything that she has that supports her damages that she has at this point. So the contracts, for example, those are all of her contracts. These don't date back to the Justice League, to her L'Oreal contracts. They are way, way before 2020. Her tax returns she produced, what Judge White ordered of Mr. Depp was that he had to produce his personal tax returns from 2020 to the present. And he had to redact out everything except what showed the gross income. Ms. Heard only has hers from 2013 through 2020. She produced those, did the same redactions, and then she also produced the tax returns from her own company because what actors do is they have a second set of corporations, sometimes that it goes through, so it gives the bigger federal picture. So she produced that as well. Then she went to the act, and I told Mr. Chu and Ms. Vasquez of this asking for the 2010, 20 because she didn't have them. We put in that request, and they were told that we were going to get them next week. I already told Mr. Chu and Ms. Vasquez we were going to produce produce those as soon as we received them. We produced all of the non-privileged and the privileged relating to the op-ed. Every single communication between Eric George and Amber Heard relating in any way, shape, or form to the op-ed. And then Mr. George was deposed afterwards. And in fact, Mr. Depp's counsel, and it was California counsel who handles this, asked for additional time after we produced those documents before we had it. So we moved the deposition almost a month so that they would have plenty of time to go through each. The agreement was made. It was before I was in the case that Mr. Chu and Ms. Vasquez were on that email and said that as long as you don't cherry pick, as long as you produce all the documents relating to the advice of counsel for the op-ed, then we would agree to the limited waiver. Ms. Heard served a 50-page expert witness designation which provides significant detail on all of her damages claimed. And it goes, there's extensive detail of her history. There's extensive explanation of all of these damages. We've done nothing to hide anything, and it's just ambush here for them to try to claim otherwise. Deposition of Eric George, Amber Heard's attorney, advising her on the op-ed was taken. Now what Mr. Chu is trying to do to get Your Honor to go through the confusion is to say that all of the documents relating to Ms. George's communication with Amber Heard should be produced. But that's not accurate, and I can cover that later. But the point is, he also represented her in this action for a period of time. He's California counsel. He came in, tried to move it back to California, was unsuccessful at that. But he was representing her in this action. So what Mr. Chu is trying to get the court to do is to develop his communications in this case, but that's not what the case law says. That's not what the Fairfax case that Judge Alden said. And in fact, he quoted exactly right that it relates to that specific advice. And that's not what Judge Ellis's opinion says. Then we also have the deposition of Children's Hospital representative. It was taken after the production of all the documents. Again, Mr. Chu made misrepresentations to Your Honor, and I'm highly upset about them. It is false that Ms. Heard has provided zero. In fact, Children's Hospital testified that Ms. Heard gave, I think it was just a little bit under $1 million to them, that she pledged the 3.5. That's not what she testified at the UK trial. She said it was gone, it was given, it's been donated, like past tense. I just don't know why you're calling attention to that, because when you call attention to it, it just gives room for them to pull up those receipts and say, actually, that's not what she said. It's easily disprovable, and in fact, the document that was written by Mr. Depp's business manager and giving the first $100,000 that should have been credited to Amber Heard because it came out of the divorce settlement was in fact credited to Mr. Depp. I seem to recall that they said that they had received $100,000 and that was the only money that they said they had gotten. And that was the one that came from Johnny Depp. So from what I understand, technically she gave zero. And maybe there was someone pledging on her behalf, but from what I understand, she personally did not give anything, and they wrote follow-ups to her about that. I digress. But he even said in that letter she's pledging the 3.5, and it would be paid over a period of time, just like an undisclosed period of time. And Miss Heard has every intention of paying the full pledge, and she started making payment to it, but she got sued by Mr. Depp. Okay, I call bullshit. Sorry. He didn't sue you till 3 years later. 3 years? Were you psychic? Did you know he was going to sue you and so you were hoarding money before? I don't think so. You could have made at least somewhat of a payment. That's not all the money that you have. She also had her own roles coming in. She probably made bank when she was in Aquaman. She could have at least made some kind of payment. And also it's not good. It's over a period of time. What was the time frame given? And so she's got a little economic issue here, and she still says she plans to do so. The other part of that is the ACLU. She paid, I think it's over $1 million there, Your Honor. She was also responsible for others donating more than $1 million. I think it's exactly $1 million to each, $500,000 to each. All of that's not relevant here, Your Honor, and that's another distinction that Your Honor needs to be careful of. Mr. Chu lunged into quoting a decision by a judge, inferring that it was Judge White. It was not. It was the California judge. Judge White said, I don't know if this is even relevant at all. I'm going to allow limited discovery, and he denied any more extensive discovery. We included as an attachment the actual statements made by Judge White in his ruling on that. We've produced documents that are relevant to her actual giving these donations. But the other thing is, then we attach this, Mr. Depp said he didn't pay a dime to her for any claims of sexual abuse or domestic violence or anything of that nature. The $7 million had nothing to do with that. It has to definitely do to your credibility. Definitely. Anyways, which ultimately we hope Your Honor will rule on in motions in limine, which has nothing to do with it. The other thing that was disturbing is that Mr. Chu argued about what was brought in front of the UK court. Well, they brought all of these donations to the appeals court, asked for. They said that it is now evidence. They want to go back in, and the appeals court unequivocally held, and I filed a notification of judicial notice. And they said that this has nothing to do with this case and whether she was domestically, violated or that there's any kind of domestic violence against her, nothing to do with that. So the other more important big picture, and I'm sorry I keep jumping around, Your Honor, but I just think it's important to get the whole context here. I held 2 more meet and confers with Mr. Chu and Ms. Vasquez. Ms. Vasquez is their California counsel who's very active in this case. We discussed all of the requests for production. We discussed everything that I just raised above. And then they said, well, can you please give us the bait stamp numbers for all of the documents that you produce that are responsive to these? Now, it's important to note that when we have issued, I think it's 12 requests for production of documents, Mr. Depp's team has never given us a bait stamp that's responsive for anything. But we said, okay, we'll do it. And it was an undertaking, and we had to go back and go through quite a few to do that, but we did it. And it was a 91-page document. 91-page document. Girl, I just finished going through a 400-page clinical records, and I'm about to start on another 300-page one after I finish this video. 91 pages? Sit down. So on Tuesday of this week, Your Honor, I was on a telephone call with Mr. Chu and Ms. Vasquez. I asked them, what else still remains? Have we resolved this completely? I think that we resolved all of the issues here. Is there anything left? I never heard from her. Instead, we get this, I thought it might be a 65-page chart that sets out every single request for production, all the objections, our initial responses, or supplemental responses, which were already in attachment 1. And there was no effort to reduce the request for production. There was no effort to engage me to say that here's what we still feel like we need. Instead, I am ambushed today. I have no clue what they were going to bring today, Your Honor. I've been asking them all the way through. This is the 4th request for production of documents, and you still don't know? This is the 4th request. I think you know, girl. I think you know. I emailed Ben Shu this morning asking him what remains for today. Did not respond. I then called him. He said, look, I don't have time to discuss. And I say, well, what are we talking about today? What's left? And he said, well, I'll just quickly give you an example. And that's what he said. We weren't providing documents evidencing the damages for one of Adam Waldman's statements that Judge White had dismissed as time barred. That was the extent of what he told me was being argued today. No idea what was left and what he felt he was still needed. You don't do it by ambush here. I highly doubt, that he hasn't sent you letters. I work in law. I know how it works. You send letters. You do things, and it's also the 4th request. It's not the 1st, it's the 4th. You must have some kind of idea. You didn't just pull this out of his ass. Okay, but anyways, but let me answer that because he's making it sound like we have some kind of obligation to go out there and search whatever damages there might have been for claims they're no longer in. We have no obligation to do that. If she had documents, she would have produced them, but she doesn't. It's moot. She has no obligation to go and help them with our alternative causality. What? Okay, no. She's also bringing a case against him. It's basically the same thing, but reversed. Meaning, if evidence kind of proves that Johnny Depp was telling the truth, then that means that she's lying. You know what I mean? It's the reverse. If there is proof that Amber Heard was abused, then that means that she couldn't have defamed Johnny Depp, which means that she could have a case against him for defamation, right? So it's the reverse. She brought her own case, so she definitely does have the obligation to back up what she's saying in that respect. The hardest part is proving the financial loss, so she definitely has an obligation to do that. We actually cited Judge White's actual statements, rulings. We cited which date, we cited the transcripts of all rulings that he gave all the way through because they were on point. What we said is we asked Johnny Depp for everything that he thinks impacted his career for the UK decision, which had to be way more enormous and any kind of op-ed. We asked about his multitude of lawsuits. He sued his business managers. He sued his former lawyers. His bodyguard sued him for drug and alcohol use. Okay, what does that have to do with this? So why would he flip? Why would the flip be true now that he has to go back to something that's no longer a cause of action and try to find evidence that supports damages? We don't have that obligation. It's no longer the case. If they want to go out and find evidence on what may have impacted it, whether they think something else may have impacted her career, that's their job. That's their burden of proof. What? No, that's what? No. And your counterclaim, it is absolutely the burden of proof is on you to prove that you suffered damages. Are you kidding me? Wow. Where did you get your degree from? And again, it's false that we have stopped April 9th, 2020. In fact, the IMDb, it's kind of the resume. It goes through and ensures everything that they've done in their entire career. We've produced that. Your IMDb page is not proof of anything. Oh my God. Okay, sorry. I just get so heated. The contracts go for a period of time. The hard drive, well, it's over 1 million documents. Mr. Chu also says if there's any statements from Warner Brothers or any of those saying they're not going to cast you because of this and this statements, believe me, if we've had those, we've produced them. Damages are on us in this case. We have to prove damages. If we have something that supports our damages, we absolutely intend to produce them. And we even said we absolutely will supplement everything, and we believe that we have provided everything that's responsive. It's on us to do that. We wanted to do that. And we will continue to supplement on anything we have. Just like Mr. Mr. Depp didn't have any correspondence from Disney saying, we're not going to cast you in Pirates of the Caribbean 6 because of Amber Heard's op-ed, we don't have anything from anybody saying we're not going to cast you in this. And really, if you think about it, the studio probably wouldn't say something like that. So even if you said that, that would be gold for us. It would be in there. We're not holding back. And if had in good faith met and conferred with me on Wednesday after I'd done what they asked with the supplements, I'd have told them we're not holding anything back. We don't have anything more. But they didn't. They didn't ask for that. So that's not how discovery motions are supposed to progress. The purpose of meet and confers is to fully disclose what's left, what can I do. I think the reason this motion was brought today, Your Honor, was as a placeholder, and then it was as abuse of this process. I think at a minimum, the court should deny this on the basis of what they've done to bring this in front of you and to blindside us. Or the other alternative, and make them do another meet and confer with me. Sidebar, this case is so contentious, even the lawyers themselves, is so contentious between them. Sitting and chit-chatting is not going to cut it. It sounds like things are even heated between the lawyers on both sides. That's why they need the judge to decide on these kinds of things, because even the lawyers can't figure it out amongst themselves. They just went through a whole slew of documents saying they haven't done this, they haven't done it. Why didn't they have a conversation with me on Wednesday? Your Honor, I asked Judge White to appoint a conciliator because I did so because we have a lot of these issues in case. What I have discovered is when you send out a set of discovery, the other side object, then you try to meet and confer, then you have a meet and confer, then they say they're going to get back to you and they don't get back to you, then we file a motion to compel, then they get back to you, then we have this whole issue of meet and confer. How have we resolved this? That's exactly what a conciliator would be able to do. Now, Judge White denied it, but I have to admit it was very close to when we thought we were going to have the trial, and I think that at this point we're done. But I think, if you know, I'm hoping the court applies and dismisses Mr. Depp's complaint and applies the UK. But if not, I really think the court should consider appointing the conciliator to avoid exactly what we're doing today. Exactly what I was kind of saying. They need a mediator for the lawyers. Like, what the fuck? That's fucked. Yeah. Okay, now let me just go through the specifics here of what I haven't already covered, and I apologize for that. You noticed, Your Honor, that Mr. Chu tries to, insinuate his version of facts of some of the things in testimony. I find that highly offensive, that because Your Honor is new in this case, Your Honor is not familiar with all of the different parts of this. Oh, wow. So that's kind of shade, like, oh, you're not familiar. I'm sure that he would have had to read up on it, like trying to kind of knock down the judge a couple pegs, and that's not a wise move. This police officer thing, Mr. Chu loves to say this, but guess what? Yellow PD corporate representative and Officer Sains and Hayden had body cam, had it assigned to them, and had downloaded body cam before and after, but somehow not that day. They kept no notes, nothing. The UK court discounted their testimony completely. I hid photographs with all the exact metadata, which have the dates and times of the pictures of Amber Heard's face, and all the pictures of all the property damage from Mr. Depp's going through and thrashing the place. I had metadata. It had the exact date and it had the time. It had all of that. Oh, you mean like you're a spreadsheet? Which is much more compelling than the two officers who didn't take any notes and for the first time didn't have body cam for reasons we're unclear about. 6 weeks later said we don't recall anything. They just don't recall her being injured or the place being trashed, which the footage backs that. Of course, if any of that existed, they would have violated policy. And that's what we have the corporate representative also from LAPD saying, yes, if these injuries were there, they needed to write in a report. And they're saying that it wasn't there. Sorry, sidebar. That's the whole point. They're saying that there weren't injuries, and that's why they didn't do a report. If those documents, if that property damage is there, they needed to write a report. That's what they're saying. Well, the UK judge properly discounted the police officer's testimony and gave credit to other people who were there, took the police officers through, escorted them, and showed them all of the damage at the time. Now, the second thing, a body cam, hour and a half later, all it did was come in, be 30 feet from Amber Heard because they said it's already been taken care of, and then they left. They weren't even close enough to see anything on Amber Heard. Oh, come on. Sidebar. If she was as injured as she said, they would have been able to see it. They would have been close enough to see redness or marks or something like that. You can see it's very, very poor quality, but it has nothing. They didn't go around and take any evidence. And by that time, they'd cleaned it up because they had doubts. What? Doubts about what? So that's an example of Mr. Chu trying to get into Your Honor's head, and say, we've got this really damaging evidence. They don't. And this is the evidence they put in the UK, and it was discounted for good reasons. Actually, girl, they didn't have that in the UK trial, but they have it now. An hour and a half later, that's not like a lot of time. If the place was as trashed as they claim it was, an hour and a half is not a lot of time. Like, have you ever cleaned your place before? It can take hours. If someone trashes your place, sometimes it can take days. I'm just being real. If the place was as trash as they claimed that it was, an hour and a half would not have been, in my opinion, enough time to have it clean, completely spotless. Also, their vibe was chill chill as fuck. They look like they were on the couch watching Netflix. Everyone was in their pajamas. The vibe was very chill. Now, he also says, bear with me just a minute. I'm going to try to go through all of this because I didn't know which ones he was going to raise. He says, with respect to the Adam Waldman, I think I've already stressed this, Your Honor, but the statements that were thrown out, we don't have any documents that support that damages, and we don't have any obligations to go and get those. But what we did produce, which they could argue is damage or not, is the tax returns, which go back to 2013, and we're going to give them the other 3 years as soon as we get them next week. We do have all of her contracts that were entered into before, during, and after. We do have her entire resume that goes back to when she first started being an actress all the way up to the present. So if those had an impact, they could track that. We do have, all of the articles and emails that had been given. We do have the entire trial bundle of the UK trial. It was 11 bundles. We call them notebooks. That's how much documentation they had. It was several rows. And it's the same kind of thing we do. They pull them out and they go to things. And they also have a lot of electronic evidence. And all of that has been produced in this case as well. So there's plenty to work with if they want to argue, oh, her career went here and here and here. They can find, oh, her income went up here and down. We've produced them. The next thing he talks about is his numbers. Production number 9. This is the impact of Adam Waldman and reputation and career. We're not going to claim damages for something that we're not entitled to claim damages for, but we've given them whatever they argued, whether they have related to her career. Communications with agents and film studios. Right. If we had them, we would have produced them. They would be gold for us. We don't have any of those, and that's what we've told them. I don't really understand why he didn't have that conversation with me. I find that hard to believe because I feel like they would probably want everything in writing for studios. I'm sure the studio keeps track of all of that to cover their own butts. It's not very professional just to do business dealings over the phone. Moving on 35, Bianca Booty. She is Heard's domestic partner, I think it's since 2019, long after all of the statements were made. The almost identical request was brought up in front of Judge White, and it was Bianca Booty, and it was violence, and we cited it, and we attached it. This is overbroad. I mean, why would a communication with a partner years later about whether he had abused her? Now, why would that even be relevant or admissible in this case? It's a fishing expedition at best. But Your Honor, we cited very, very particularly in our brief Judge White's ruling on that and with the request one that was virtually identical to that and just doesn't make any sense. It's overbroad completely. The second category, Your Honor, where he says we refuse to confer. He's never asked us to confer. But I think what he's asking is for Your Honor to overrule all of the objections, but that wouldn't make sense in this case because we spent the time to go through. Our objections are exactly what the court ruled. For example, number 2, we had July 24th, 2020. What the court ruled on request number 14th of second request and the same thing, and it was overbroad. We cited his ruling on September 18th. Cited saying, no, the judge didn't rule this way. Then these objections were valid last time and they can't do this. We went through, Your Honor, some of these. We even bolded the ones that were directly on point and the exact same request. So there's not a situation here where we are hiding something, but these are legitimate objections because they are overbroad. What does Amber Heard have an obligation to do here on searching this? Go back years and see if there's ever a mention of, yeah, I got hurt when he hit me on one of the times. I mean, it just doesn't make any sense. So then he says, yeah, we've already talked about the tax returns, and he has kind of misstated that one quite a bit. But we do intend to go all the way back to 2010, do exactly what the judge ruled for Mr. Depp. And we've already told them that the ones that we went out of our way and requested the earlier ones. We understand they may be here as early as next week. And as soon as we receive them, we'll give it to them. And we went over above, not just her personal. We went for her loan out company as well because that gives a better and more accurate picture. We're trying to be as accurate and comprehensive as possible. The third category has a whole series of these. The impact of the relationship. These are the ones that Judge White specifically ruled as incredibly overbroad. And we cited exactly what the judge said and exactly what the request was, and we attached them to our brief. We're not misstating anything. We're not taking anything out of context, but Your Honor asked exactly the right question. How are we supposed to prove these? What impact to this? What impact to that? If we had a responsive documents, we would have produced them. We're not aware of any, and in some of these, and we've said we're not aware of any responsive documents. Now Mr. Chu adds a new obligation. He says, well, you have to say a reasonable search has been conducted. Well, isn't that implied in everybody's responses that they've engaged in a reasonable search? And then you have to say that Miss Heard agrees to produce them if she comes upon some. That's the rules on supplementation, Your Honor. We are bound by that. We don't have to say that in our responses. Then we get to the charitable deductions, and I think I covered a lot of this earlier, Your Honor. But we've produced the documents relating to the charitable deductions for ACLU and Children's Hospital. They go much further here, and they're asking if there was an anonymous donor who donated $500,000 to each of the charities in her honor, which are not credited towards her pledge. She still has to make the rest of her pledge of the 3.5 to each, and she fully intends to do that. And by the way, the ACLU document showed that it was anticipated to be over a 10-year period. Oh, really? Because as far as I know, thing regarding ACLU has been produced, so why wouldn't you produce it then, since it proves that you weren't lying? Children's Hospital in their testimony said many times we don't put limitations on pledges. Yeah, they can be made a lot later. There are a lot of different types of pledges, including ones that you put it in your will. I mean, of course, they're not gonna say no to charity. They'll take what they can get. Following up like, so about that pledge, you ever gonna pay that? They were not assuming at any point that it was going to be paid up front. No, but they're probably assuming that some type of payment, even like $1, $5, $10 would be made. They've asked for documents outside of the documents relating to specific pledges. They are specific communications with ACLU and Children's Hospital. They're asking about all the information relating to the anonymous donor. Well, they already asked that before, and Judge White said no. In fact, Judge White, in sharp contrast to California judge, he said, I don't really think any of this is relevant, but I'm going to let you have the first part of this, but I'm going to overrule you on the other requests. Then they turned around and made the request again. But she's turned over the ones that relate to what she has produced, her checks, her emails, her communications. They also subpoenaed the Children's Hospital. They turned over theirs. They also subpoenaed the ACLU, and I understand that they are in negotiations on that, and I'm not involved in that. And the ACLU, I believe, is cooperating with them and turning that over. And that's, fine. I still think that it's not relevant, but we've produced that. But going beyond and saying that all of her motions relating to anonymous donor, what does that even mean? That's fine. I still think it's not relevant, but we've produced that. But besides that, they know who the anonymous donor is on one of them because Ms. Heard's emails reflected that. And I think, yeah, that's something else. In respect to the statement, it's incorrect. Ms. Heard has indicated Mr. White is Mr. Depp's business manager. He's the one that wrote the letters to ACLU and to the Children's Hospital. And he said and gave $100,000 to each on behalf of Ms. Heard. And he said right in the letters, it's a pledge of 3.5 to be paid out over a period of time. The draft op-eds, I think I talked about it earlier. We've produced everything. We did it. It was that's non-privileged. Their agreement that if you don't cherry pick, we agreed to the limited waiver, and that's the law. And both Judge Alden and Judge Allah say the same thing on that. Ms. Heard has a criminal record. No, she doesn't have a criminal record. They have done, and this is another beautiful example of just how they try to grab the court and make these statements that are just outrageous and out there. There was an occasion, well, I think it was back in 2006-07, somewhere in there, where she was in an airport in Tacoma, Washington, with her partner at that time, and there was a police officer who made an arrest of her because she grabbed her partner's wrist and pulled it. It ended up getting dismissed. They didn't press any charges. They said they couldn't, and that there wasn't sufficient evidence for it. That's not a criminal record, as Your Honor well knows. But here we go again. Oh, she has a criminal record, and Mr. Depp doesn't have a criminal record. The bottom line, Your Honor, is that there's an enormous amount of evidence in this case because Mr. Depp chose to bring this case in the UK first, where they have a better burden of proof that it was on the defendants, the son and Mr. Wooten, to prove that the wife beater and the domestic assaults were false, instead of Mr. Depp having to prove that they were false. They had to put that there were two, as opposed to Mr. Depp having to prove that they were false. He chose that for him. He had an extensive amount of litigation, and I hope to be bringing that to Your Honor sometime after I get to be heard at the end of May on opportunities for even setting the hearing date and setting the briefing. But an enormous amount of evidence was in that case. It was well over 16,000 documents itself. All of that is in this case. And then there's been at least another 16,000 produced by Ms. Heard independent of the million. And she's detailed the 50 pages of the expert designation. This motion shouldn't have been brought, Your Honor, and it was irresponsible to bring the second time identical, knowing how much evidence had been produced in the interim, and knowing that we had meet and confers, but that we were making this effort. But it was also an abuse of this process to not continue to work with me to know this before coming to Your Honor today and play hide the ball and try to in some way surprise me with what they were going to claim still wasn't. Court. All right, thank you, Mr. Chu. Mr. Chu, Your Honor, if I could have just a few more minutes for rebuttal. The court has been very indulgent with its time. Mr. Court, great. Chu. Quick, which has raised some issues that I would like to address very quickly. This is Depp's counsel. First, with respect to the chart, we apologize if we filled the chart out incorrectly. This is our first experience with it. We weren't trying to be ponderous. We're trying to respond to the court's request. Second, with respect to the conciliator, it is ironic. We oppose the conciliator not because we don't want to conciliate, but because we knew that Ms. Bredehoff would try to relitigate every single discovery issue that had been resolved by Mr. Chief Judge White. And Chief Judge White stated that, and I know what Mr. Chu is saying is true, you will, Elaine, try to relitigate everything that's happened, and that's why I'm not appointing a conciliator. But, to get more substantive matters, Ms. Heard did not say that she pledged the money to the ACLU and to the Children's Hospital of Los Angeles kids with cancer. She said she did it. Her testimony was, the entire amount of my divorce settlement was donated to charity. This wasn't an offhand comment in deposition. This was a sworn statement that she filed. She didn't say she pledged it. She's now saying after the fact, oh, gee, no, I really haven't given any money to those charities other than the $100,000 that Mr. White gave at the time of the divorce. It was I couldn't really give the money because, Johnny sued me. Well, her lawyer admitted that it was Ms. Heard, in fact, who initiated the first action against Mr. Depp. It was an arbitration matter that was dismissed by Judge Meisinger. So she was the one who actually fired the first shot and had no intention of giving this money to charity. Fourth, with respect to the additional communications relating to the CHLA and the ACLU, these are clearly responsive. They have not been ruled on. Elon Musk is in fact the anonymous donor. It's relevant for several reasons. One, Elon Musk is on film as having seen Ms. Heard in the days after May 21st, 2016. That's the date where all the four police came to the condominiums and all testified there was not a sign of damage on Ms. Heard's face and there was no disturbance to the apartment. I'll get to that in a moment. But the point is, Mr. Musk saw her in the week between the alleged abuse and the time she got the ex parte TRO on May 27th of that week. So he's clearly a relevant person. We have testimony in this case from Jennifer Howell that Miss Heard has had a dispute with Mr. Musk because they've produced eggs together, according to Mr. Howell, that Miss Heard wants to keep and Mr. Musk did not, which may or may not explain why he made his charitable foundation made contributions in her honor. But none of that gets besides the point that, in fact, she failed to honor her $7 million charitable contribution. And it was of such moment to Miss Heard and Miss Bredehoff that when the CHLA finally did produce those documents after the Court of Appeals opinion came in, and I believe I was accurate in representing to your honor that it wasn't Chief Judge White's words I was quoting, it was Judge Bowick's words that I was quoting, when she said it was very relevant. When the CHLA finally produced those documents, Miss Bredehoff designated them confidential under the protective order. I, Mr. Depp, filed an emergency motion to redesignate those documents because they were needed. And Miss Bredehoff said there's no emergency here. They don't need these documents in the next few days. And Chief Judge White told us the emergency here, Mr. Bredehoff, is your bad faith. So he granted the emergency motion to redesignate the CHLA documents because he knew they were relevant and he knew that they weren't confidential. Your Honor, the notion that Miss Bredehoff is somehow ambushed by this motion to compel is risible. We filed this back in January, and with all due respect, and she's had some issues going on. There were issues in the transition, which we respect. But we did file the same motion back in January, and that was after several meet and confers have been had. We've had several meet and confers since we filed. So the notion that this was somehow all of a sudden, it just doesn't pass the straight face test. And you've heard Miss Heard did spend a night in jail for abusing her domestic partner. And so, any communications that she had with Miss Buddy, her current girlfriend, or anyone else on the subject of abuse, it's not just her. It isn't any communications she's had with anyone on the substance of abuse is relevant. For example, we understand that she had communications with her father where it was clear that she was abused. Those would be relevant here. But getting your honor to, and just very briefly, on the testimony of the police officers. Chief Judge White found the testimony of Officers Sains and Hayden, which they gave in the context of the divorce action within 2 months of May 16th, 2016. So in July, just 2 months after the alleged incident where Miss Heard says that she was hit or that something was thrown at her, these officers were deposed by Mr. Depp's divorce lawyers and Miss Heard's divorce lawyers because she first came up with these abuse allegations in order to get the $7 million that she got. Because there were no children. It was a 15-month marriage, and she knew she wasn't going to get very much, so she alleged abuse. And the police officers came the night of May 21st. They didn't know what it was. It involved Johnny Depp because Miss Heard wouldn't tell her who the alleged abuser was, and they didn't know who Amber Heard was. So the notion that these police officers maybe gave him an OJ break because he's famous or they like his movies is ridiculous. The lead officer, Officer Sains, is a woman who has handled over 100 domestic violence cases. And her assistant, the junior officer, was a very reputable officer. And they both examined Miss Heard's face where she said the injury was. They saw no signs of any bruising or any swelling. They went through the entire condo. They found no evidence of, mayhem. And that was confirmed by the second set of officers who came and had their body cam. And I have to note the comment made about Officer Sains and Hayden. Miss Bredehoff deposed these officers and they said very clearly they didn't have body cams. They didn't not turn them on. Body cams were just coming online. Some of the officers were assigned body cams, some were not. So the notion is really outrageous and insulting. But getting back to the facts at issue, because I know your honor doesn't want to decide he said, she said. What we're here for today, and again, we noticed this a long time ago. And as to April 30th, Miss Bredehoff agreed to April 30th long time before she came up with what is now Miss Heard's third motion to dismiss. We're going to oppose it because she's already had 2 bites at the apple. She cites 2 sets of demurrers, 2 sets of plea and bar, and they've been thrown out. And now she's trying, for the 3rd bite at the apple. We think that should not be allowed at this stage. We also think it's futile because Mr. Bredehoff knows, and we all learned in law school, that for res judicata or collateral estoppel to apply, you have to have the same parties. Miss Heard was not a party to the London action, and the London court had no ability. And that knocks out res judicata and collateral estoppel right there. That's the first requisite article requirement we've all learned in law school. Mic drop. But there's also substance behind that formulae of rule, which is the court in England had no power over Miss Heard. They didn't even know whether she was going to show up to testify. There were no depositions of Miss Heard. Mr. Justice Nicol, who was hornswoggled by her testimony that she couldn't be an adventuress, she couldn't be a money grabber if she gave all her money to charity. He didn't know that that was a lie, because she wasn't deposed, and she was continuing to lie. And the CHL, she was continuing to resist discovery in Virginia. But what we're about here today is, Your Honor, Miss Bredehoeft says, gee, Your Honor, we're all going to produce everything that supports her damages claim. We have every interest to do that. Of course she does. But we're entitled to not only to what supports Miss Heard's damages claim, we're entitled to what relates to Miss Heard's damages claim. And with respect to her other, we never said that Miss Heard hasn't produced a single document prior to April 8th, 2020. What we're saying is that her objections, which she told me this morning she was standing on, she just admitted it. Her objections on what she's standing is, we don't want to produce documents prior to April 8th, 2020. We may give you some, but we're not required to. So what we're asking, Your Honor, is that Your Honor look at her objections that she's standing on and overrule them. And for respectfully that Your Honor order her, Miss Heard, to produce all documents, all non-privileged documents, responsive to the document request at issue on or about May 21st, 2021. And if she's produced them already, or if none exist, well then there's no prejudice to Miss Heard. The one issue I think we need to come back to, however, is with the issue to respect to the waiver of privilege. Your Honor, the waiver, there was a waiver here. Mr. Gilmer's statement, back on September 4th, 2019, was more than a year before Miss Heard filed her answer and submitted her defense of counsel defense as the fourth affirmative defense to Mr. Depp's claim. And both the case that, Judge Ellis's case and Judge Alden's case, make very clear that whereas here, a party, Miss Heard, the defendant, asserts a defense of counsel, that there's a waiver as to that issue. And Miss Bredehoeft, pushes an open door. She's saying, Mr. Chu says he wants all the communications between Miss Heard and Mr. George while he's acting as her counsel after Mr. Depp filed this complaint. Not so. But we're asking for all the communications that relate to the defense of counsel affirmative defense. Now, the temporal period of that is going to be the time before she would publish the op-ed, which would include all drafts of the op-ed. Any communications between Mr. George and Miss Heard going to the issue of, gee, Amber, is any of this true? I would like to know whether he, and more importantly, Mr. Depp would like to know what, if any, due diligence Mr. George did. We know the ACLU did no due diligence before they had gotten bad with Miss Heard. We know the Virginia Press Association, which moved to intervene earlier in this case and filed an amicus brief, which Chief Judge White denied. They admitted that they didn't take or do any due diligence of Miss Heard before jumping onto her Me Too cause. I mean, remember, there's Jesse Smollett. There are people, anyway, Your Honor, what we're asking the court is that the court look at her written responses, her written objections on which she's standing, and respectfully that Your Honor overrule them so that on May 21st, we'll either have all the responsive documents or we'll know that none exist. And as to the privilege, as I've just laid out, that clearly has been waived, Your Honor. And thank you very much for your time. The court. Thank you. I do not know that you don't have... The court says, thank you. I do not know that you... I do now know... Court says, thank you. I do now know that you do not know how much 2 minutes is, Mr. Chu. I figured that out. I apologize. The court, that's all right. So this is the judge. It's interesting, and I did want to hear all the arguments on this, on the matter for the motion to compel. It does appear that if just coming into this case as I am, it appears that you both are talking about different cases by the way you're discussing how much has been turned over and how much hasn't been turned over. It leaves me in a difficult position just to be able to rule on all of these requests based on that. But we're going to do it because we want to keep moving forward in this matter. Take that! Anyways, okay, as far as the scope of documents to be produced, it appears that both of you agree, although it seems like there was some issues. So we'll put it in an order that the documents, the date we're talking about is January 1st, 2010 for documents. So that should take care of the scope of the documents to be produced. So as far as the request for production, I think it was 9/11 through 14, 16, 18, 20, 22, 24, and 29. So that's January 1st, 2010. Also, in dealing with some of these RFPs, we are talking about previous statements that are no longer at issue. However, they can still be relevant to mitigating damages in the sense that the time bar statements could have caused damage to reputation, not the statement sued on. So even though Ms. Bredehoff says, well, I'm not going to base it on my damages, it could be used to mitigate damages for the plaintiff. So based on that date, I am overruling the objections as to those requests for production. And I want to make sure I get them all. I think it's 7, 8, 9, possibly 10. So on that basis, whichever ones work with the statements that are no longer part of those cases, they still have to provide the discovery if there's any discovery to be provided. I think we talked about requests for productions too. Okay, number 2, 3, 4, 5, 6, 8, 2, 3, 4, 6, 8. And I believe 28 was part of that, and 28 through 33. As to those, we're talking about the objections being vague, overbroad. Judge White ruled on, it was different when Judge White ruled on it in July 2 of 2020, because at that time it was income from all sources from 2010 to the present. I think it has been narrowed now where it just talks about any monetary from film, movie, television, commercial. So it has been narrowed down in that aspect, so I will overrule the objections when it comes to the request for production, because they have been narrowed down to talk about film, television, commercial, or other project 2010 to present. Mr. Chu, we would also request numbers 38 to 42, the judge. Let me check 38. 38 through 42 has to do with communications, but these were the charities, so we talked about the charity. We can do that next, that's fine. Judge White did rule on this issue. However, based on his ruling, there's information that was found by the plaintiff which led us to more information, which is now, I assume, what I gather from the arguments that they're now basing these requests on. So based on that, I would overrule their objection as to 37 through any and 38. And as far as 39, 40, and 41 that relate to anonymous donations on their behalf, I don't see the relevance. I understand that it was proffered that Mr. Musk is an important person in this case. Maybe he is, maybe he isn't, but I don't see the relevance of the anonymous donations. So I'm going to sustain the objections as to 39, 40, and 41. 42 relates to 37, 38, so I will overrule the objection as to 42. Miss Bredehoff, you had a question? I'm sorry? I did, although I was probably just making noise. I'm sorry, I did. Okay, Miss Bredehoff, okay. I'll continue on, then at the end. Excuse me, okay, I can continue afterwards. Okay. Cut that out, okay. Now I'm going back to 18. 18 deals with the limited waiver issue. Based on the case law and based on what I heard in argument and also in your motions, at this time, Ms. Heard is asserting a defense of counsel. When she does assert a defense of counsel, she's waiving her attorney-client privilege with respect to this transaction, which in this particular case is the transaction of the op-ed published. Therefore, she must turn over any, to include with Mr. George, any, which Ms. Bredehoff already says it has been turned over, but without the limited waiver, though, any of those communications dealing for the op-ed and any drafts of the op-ed. So that should take care of 18 and 19. Okay, so overrule the objections as to those, and then I believe Ms. Bredehoff has said that 5, 7, 8, and 37 have all produced what they have. If she is correct, then indeed you have to do supplemental responses if you do come across them. And it should be known that that is a reasonable search. So 5, 7, 8, 37 I think are moot points because they have been turned over. And they would just have to be any extra language added to those. And now we know that impact means the commercial effect. So we'll keep that in consideration as to commercial effect of monetary issue. What am I missing? Tell me what I'm missing. And then Mr. Chu goes, oh, Your Honor, I just had a threshold question. Would you like us to submit a proposed order if Your Honor is going to eat? The judge goes, yes. I'd rather you submit an order and kind of note your objections on it, and we can move forward from there. Mr. Chu, what we've done in the past, subject to Your Honor's approval, is we've taken the transcript, looked it over the weekend or on Monday, and perhaps if you could submit your proposed order by this coming Wednesday. The judge says that's fine. Does that work for you, Ms. Bredehoff? I'm fine with that, Your Honor. If I may make a clarification, This is Amber's alarm. The January 1st, 2020, the tax return. I just want to make sure that we're saying, she said, Judge White ruled that Mr. Depp only had to produce gross income on tax returns and that everything else can be redacted. They didn't need to produce the schedules. And we're assuming that's the same for us. Is that correct? Judge says, all right, Mr. Chu, do you have an objection to that? Mr. Chu, well, one thing we would like, Your Honor, and I'm not enough of a tax maven to understand this, but Ms. Heard's counsel has represented that she's paying her own attorney's fees. We believe they're paid for by the anonymous donor, Mr. Musk. What we'd like to see is whether there are any deductions for attorney's fees on those tax returns, because we've always... Ms. Bredehoft, yeah, with regard to that, but first of all, I haven't made that representation. Second of all, that's not relevant. Mr. Chu said Mr. Rottenburn did. The judge says, don't talk over each other, please. Ms. Bredehoft, he's been making that up, that Elon Musk has been paying for attorney's fees. It's 100% false. That I have had conversations with Mr. Chu, but that has nothing to do with this case. And Mr. Depp wasn't put in that situation of where he pays for his attorney fees. And there's no reason why Ms. Heard should, and he didn't ask for it. I think if later that becomes relevant, Mr. Judge said White said the attorney's fees are reserved for later. We're not going to put that on during this case around this trial. So whatever those attorney's fees are, that's something that we can deal with later, but that's not fair. First of all, he's misrepresenting what I've said, misrepresenting the truth. And second of all, it has nothing to do with this case right now. Mr. Chu says, very briefly, since I've been accused of misrepresentation, Mr. Chief Judge White has instructed me that I don't have to respond to things like that from Ms. Bredehoft, but I will. Mr. Rottenburn, who's currently still co-counsel for Ms. Heard, represented to Chief Judge White on more than one occasion that, in fact, she's paying her own attorney's fees. If that's the truth, it should be reflected on her tax returns as a business deduction. That's all that we're asking. I mean, we would just like to see whether she's taking deductions for attorney's fees or not. Ms. Bredehoft says, Your Honor, that's said before, Your Honor. It wasn't raised in any of these briefs, and I am 100% certain Mr. Rottenberg did not make that representation. The judge says, that's fine. Either way, I'm just going to have the tax returns done the same way with just the gross income on them. Okay? Yeah, okay. Ms. Bredehoft says, Your Honor, actually, I would ask for more time than May 21st. We are moving. We are asking the following Friday for a stay of discovery because during the time that we're briefing the application of the UK judgment to this case, a number of the issues that Your Honor worked on today would be affected by the stay. In any event, that's really not enough time for me to work with my client, and I would like a minimum the following week. But I would ask that Your Honor considers this being part of the stay if Your Honor considers this. Mr. Chu says, Your Honor, if I may be heard very briefly. Mr. Chu says, this is the third time around for Ms. Heard. When she had Mr. George as her counsel and he moved to dismiss, there was a long period of extended briefing. There was argument that Chief Judge White took the matter under consideration. It lasted a few months. There was no moratorium during the pendency of which Judge White denied. Then she got a new set of lawyers, Robbie Kaplan. They were granted leave to start all over again, to do a demurrer, to do a plea in bar, new theories. Same thing happened. There was an extended briefing scheduled. There was an argument to Judge White, who, for the most part, overruled the demurrer. Same thing. There was no moratorium during that. Then Ms. Heard filed her counterclaims, and we filed her plea in bar and the demurrer, most of which was sustained except as to the 3 statements Mr. Waldman made. We didn't ask for a moratorium of discovery during that period that we were successfully demurring and move on the plea in bar. So we don't see any reason whatsoever why she should get a moratorium of discovery based on, of the 3, this is the least substantive motion to dismiss. The first one was an interesting issue on what constituted, venue. That was the second one, there were some arguments to be made. Here, this is black letter law. So even if this were a righteous motion to file third set of responsive pleadings, which we don't think it is, we don't think it's a basis for a moratorium. We would agree until May 28th, but we certainly don't want a moratorium, to go out, into the summer. We haven't taken Ms. Heard's deposition yet. We need these materials to do that. The court says, all right, let's make it May 28th. Yeah, I wasn't asking for a moratorium today, Your Honor. To be clear, I was... The judge goes, okay, let's make it May 28th in the order, okay? So, that's it. The rest is just... blah, blah, blah. So, yeah. Wow, that is it. So, it looks like Johnny was mostly successful in this. So, I definitely agree with Johnny's lawyer, and who killed it, by the way. That turned into slightly kind of a dramatic reading of his, but he really killed it with that. Oh wow. So, and I do kind of agree with him. Like, it's just, there should come a certain point where her lawyer, or if she ever changes lawyers, there should be almost like a bar from them trying to pull this stuff, because if the previous attempts at getting this case thrown out didn't work, I don't think the outcome of a case where she was not even a named party to the case in a different country, I personally don't think that's going to get thrown out. And based on, you know, the judge, I think if it was even a question in the judge's eyes, I would almost make more sense to hold off on ruling about this, because it's like, well, what's the point if there's no case, right? So the fact that the judge is making these rulings and these orders to compel production of documents, it kind of seems like the case will move forward, because otherwise, what the fuck is the point, you know? So, yeah, that's good news for Johnny, and, you know, I'm curious to see what happens moving forward, and yeah, I don't know. I think I kind of like this judge so far. So we'll see what happens. So what do you guys think about all that? Comment down below. Let me know your thoughts. This is probably going to be a really long one. But yeah, I'd love to hear from you guys. And I've got more content coming. And yeah, I just felt like really inspired to go old school and just react. Even though I have so much work to catch up on, I just wanted to do this first and get myself into the paralegal groove and just get fired up on paralegal vibes. Paralegal vibes. Okay, guys. I guess that's it for this video. It's long enough already, but thank you so much for watching. I appreciate each and every one of you and all your sweet, kind comments. And you guys mean so much to me. And yeah, I'll catch you in the next one. Bye, guys.